here. Okay. Reading corporations overview in brief. A corporation is a legal entity apart from its owners, the shareholders. Generally, only the corporation and not the people who own or work for the corporation is liable for the corporation's obligations. To qualify for this entity treatment, the corporation must be formed by filing a document with the state. In most states, the article of incorporation, setting out certain information, rules for corporate governance may be set out in the articles or in the bylaws adopted by the corporation. Ownership interests in the corporation are then sold in the form of stock or shares, which give the shareholders certain rights. For example, to receive distributions when declared and to vote. Shareholders elect directors who oversee the corporation, and the directors appoint officers to run the company on a day-to-day basis. Directors and officers owe the corporation a duty to act as similarly situated persons and cannot self-deal for their own benefit. Before a fundamental change can be made to the organization or corporation, shareholders must be informed and given an opportunity to vote on the change. Part 2, organization formation of corporation. Part A, have articles of incorporation been filed. Listing 4 parts here. The name of the corporation must be included. Cannot be similar to existing names. Number of authorized shares must be included. Also must include the name and address of incorporators and their registered agents. Watch for clause limiting corporation's purpose. Activities beyond purpose are ultra vires and may be enjoined, or directors held liable for authorizing such acts. All right. So when does the corporation begin? 1, when the articles are filed by the state, or 2, promoters generally liable for pre-incorporation contracts. A, under promoter liability is liability continues even after corporation formed, absent a novation. And B, corporation does not become liable unless it adopts. Part C, what if there are defects in formation? 1, a person who reports to act on behalf of a corporation knowing there is no incorporation is personally liable. No liability if de facto corporation, which is A, or characterized as A, colorable compliance with the incorporation statute, and B, exercise of corporate privileges. Now, 3rd, under defects to formation is no liability if corporation by estoppel. People treating business as valid corporation are stopped from denying corporation's existence. 4th, some states do not recognize de facto and estoppel doctrines. And 5, where no corporation recognized, only those who acted on behalf of the business will be held liable. Passive investors not liable. So that's the de facto and estoppel doctrines. We didn't say that de jure is the name for a properly formed corporation, unless I missed it. Part D, Will court disregard corporate entity and pierce the corporate veil? So there's one, the alter ego doctrine. Within the grounds is that the harm is caused to third parties because, one, owners do not treat the corporation as a separate entity. 2, commingle personal and corporate funds. 3, use corporate assets for personal purposes. 4, owners do not hold meetings. Part B under the alter ego doctrine is that the parent subsidiary corporations or unaffiliated corporations can be held liable for this. 2, inadequate capitalization at inception. A, must start corporation with sufficient unencumbered capital to meet its prospective liabilities. 3, perpetrating a fraud. A, cannot be formed to avoid existing liabilities. And B, can be formed to limit future liabilities. And fourth, a court pierces generally only active shareholders liable and generally liable only for tort obligations. Part E, capital structure of a corporation. Debt securities, bonds create debtor-creditor relationship. Equity securities, stock create ownership interest. Terminology. 1, authorized but issues shares are shares described in the articles but not currently issued. 2, issued and outstanding. Shares sold to investors. 3rd, treasury shares. Former name for shares repurchased by the corporation, now called authorized, but unissued shares. Subscription agreements are agreements to purchase shares from corporation. 1, pre-incorporation subscription agreements are irrevocable for 6 months. Pre-incorporation consideration for shares. 1, acceptable form. And under number 1, I guess what's acceptable is under the Model Business Corporations Act, any benefit to the corporation. And B, traditionally only cash, property, or services already performed. Amount under MBCA, amount set by directors and their good faith valuation of the consideration received is conclusive. B, traditionally shares. Oh my gosh, trying to do 2 things at once. Traditionally, shares often had a par value, minimum consideration, and could not be sold for less. Next section is part 3 about shareholders. So, voting. A. 1, generally shareholders do not run corporation on a day-to-day basis. Exception, closely held corporation may dispense with the board by shareholders agreement and run corporation through a different scheme. B, shareholders indirectly control the corporation by electing directors, amending bylaws, and approving fundamental changes. Record shareholders. Shareholders of record on the record date have a right to vote. 1, at the annual meeting to elect directors. 2, regarding fundamental corporation changes. 3rd, notice of meetings must be given to shareholders. An annual meeting, the date, the time, the location. For a special meeting, the same plus the purpose. Improper notice, action taken at the meeting can be nullified and can be waived by attending without complaint. Proxies. Right, so a person who attends and doesn't complain can't raise the improper notice as a issue later, I suppose. Proxies. Written proxies are valid for 11 months. B, generally revocable unless they specifically provide otherwise and are coupled with an interest. C, may be revoked by attendance or later appointment. Federal law. 1, proxy solicitations must fully and fairly disclose all material facts. Two, prohibit material misstatements and fraud in connection with a proxy solicitation. 3, materiality. A reasonable shareholder would consider it important in deciding how to vote. 5, quorum. Generally, generally a majority of outstanding voting shares must be present for a valid vote. Once quorum reached, shareholders shareholder leaving does not invalidate voting. Approval. MBCA, if quorum is present, and that's a Model Business Corporations Act or something like that, that I stated earlier. If quorum is present, action approved if votes cast in favor exceeds votes cast against. That's ordinary, according to the lecturer. Some states require greater vote for fundamental corporate change, cumulative voting for directors. MBCA allows articles to provide for cumulative voting. Cumulative voting is automatic in some states. Mechanics, shareholders can vote shares owned times the number of directors being elected, can cast all votes for one candidate or split. Shareholder agreements, Part B, voting trusts. Shareholders transfer share ownership to a trustee who votes shares as agreed, valid in most states for up to 10 years, but renewable. 2, shareholder management agreements used in small corporations. Shareholders may agree to run the corporation in any way, can even dispense with a board. 3, share transfer restrictions. Ownership interests or shares generally are freely transferable. Shares may conspicuously provide for restriction. Restrictions must be reasonable. Part C, inspection rights are limited. Books, papers, accounting records, etc., within 5 days written notice, and there must be a proper purpose, a purpose related to the shareholder's rights, and an unqualified right, regardless of purpose. Articles and bylaws, minutes of shareholder meetings, names and addresses of current directors, and recent annual reports. Right, so those should be available, but I think it may require that you actually are a shareholder, but I could be wrong. Preemptive right. Right to purchase shares to maintain proportionate ownership interests. Under MBCA exists only if provided for. Where provided for does not apply to A, B, C, or D. A, shares issued as compensation, shares issued within 6 months of incorporation, shares issued for consideration other than money, and D, non-voting shares with a distribution preference. Part E, shareholder suits, direct versus derivative. Direct suit is to enforce right of shareholder. Derivative suit is to enforce a right belonging to the corporation. 1 must have owned shares at the time of the wrong. That's required for a shareholder to bring a shareholder derivative suit. 2 must maintain ownership throughout suit. And 3, demand board to bring suit unless futile in some states. Dismissal. If a majority of directors with no personal interest determine in good faith that suit is not in best interest of corporation. And then 3rd, recovery. Direct suit goes to the shareholder, but in a derivative suit, it goes to the corporation usually. So part F is distributions. generally are in the form of dividends or assets after dissolution. No right to receive until declared by board. Insolvency limitations, no distribution if one, corporation is unable to pay debts as they become due. 2, total assets are less than total liabilities. B, preferences, shares may have a preference to distributions. And there's 3 types. Cumulative if earned and participating. So cumulative, if distribution not declared or paid in a certain year, it accumulates until paid. 2, cumulative if earned. Preference accumulates only if profits for a year were sufficient to pay preference. Participating receives stated preference and a share of the distribution made to common shareholders. Director liability, director who votes for an unlawful distribution is personally liable for the excess. 2, director may seek contribution from other directors who voted for distribution. And 3, directors may recover from a shareholder who received a distribution knowing it was unlawful. And last, good faith defense may rely on accountants and reliable officers and employees who indicate distribution is lawful. Part G, shareholder limitations. Shareholders, not fiduciaries, may act in self-interest. Exception, controlling shareholder cannot use control to obtain a special advantage at the expense of the minority shareholders. Directors, voting, meetings. A, directors must attend in person, no proxies, or through telecommunications equipment if all participating directors can simultaneously hear each other. B, no particular notice required for regular meetings. C, special meetings typically require 2 days notice of date, time, and place, but not purpose. D, quorum of directors must be present at the time vote is taken. And E, approval of action requires affirmative vote, a majority of the directors present. 2, delegation to executive committees may exercise authority given to them by board, comprised of 2 or more directors in most states. Exceptions, in most states, committees may not declare distributions, fill board vacancies, or amend the bylaws. Part B, liabilities and indemnification. 1, liabilities. Business judgment rule generally protects directors from personal liability to corporation or the shareholder. 1, director must act in good faith. 2, with care that a person in like position would exercise. And 3, in a manner reasonably believed to be in the best interest of the corporation. B, articles may further limit or eliminate personal or director personal liability to corporation or shareholders except 1, to the extent director received improper benefit, 2, for liability for unlawful distributions, or 3, for intentionally inflicted harms or criminal violations of law. C, reasonable reliance defense. Director may defend suits with the claim of reasonable reliance on opinions, reports, etc., prepared by experts or reliable employees. D, waste. A director has a duty to prevent corporate waste. E, no self-dealing without disclosure and approval, duty of loyalty. 1, a transaction between a corporation and a director will not be set aside for self-dealing if the director disclosed all material facts and transaction, was approved by disinterested directors or shareholders, or the transaction was fair to the corporation. Corporate opportunity doctrine. A director may not divert to himself a business opportunity within the corporation's line of business without first giving the corporation an opportunity to act, aka usurpation. 2, remedy. Corporation may recover director's profits or force director to convey the opportunity to the corporation. 2, indemnification. Before we go into indemnification, let's just open this up a little bit more about the liabilities. Like the fact business judgment rule is being named here. It protects directors from personal liability, but you got to act in good faith with the care that a person in a like position would exercise. That's going to be the key definition for duty of care, at least as this overview would be concerned. So in good faith, with the care that a person in a like position would exercise, and in a manner reasonably believed to be in the best interests of the corporation. Might even write that down. Here we go. Articles may further limit or eliminate director personal liability to corporation or shareholders, except to extent director received improper benefit for the liability of unlawful distributions or for intentionally inflicted harms or criminal violations of law. Reasonable reliance defense. Waste. No self-dealing without reasonable reliance is like on an accountant or expert, reliable employees. No self-dealing without disclosure and approval, duty of loyalty. So this is key. A transaction between a corporation and a director will not be set aside for self-dealing if a director disclosed all material facts and transaction was approved by disinterested directors and shareholders, or the transaction was fair to the corporation. And I guess that's it in self-dealing - duty of loyalty. But I was told by the lecturer to memorize duty of loyalty, and I know there's a lot more to it. Corporate opportunity doctrine, we discussed that. Usurpation idea. Indemnification, successful defense. If director is sued as a director and successfully defends, corporation must indemnify for expenses. Unsuccessful, if director is unsuccessful in defending, corporation has discretion to indemnify if the director complied with the business judgment rule standards. For exceptions, the director is found liable to the corporation or received an improper benefit. And C, corporations may purchase liability insurance to cover directors even if they would not be entitled to indemnification under the circumstances. Part 5, officers, required officers, appointment and removal authority. So for required officers, MVCA does not require any particular officers, but rather allows corporation to have officers described in bylaws or appointed by directors. Some states require at least 2 officers, a president and a secretary, to certify corporate acts and records. Generally, a person may hold more than one office, but some states prohibit both president and secretary from being the same person. Appointment and removal. Officers are appointed by the board of directors, not the shareholders. Officers may be removed by the board of directors. If removal is in breach of contract, officer is entitled to damages. Authority. Officers have the actual authority to give, given by the board, articles, and bylaws. Officers have apparent authority to do whatever someone in their position would normally have the authority to do. All right, so what more is there to this? Liabilities and indemnification. Officers owe corporation duties similar to those owed by directors. So what I read in the last part about care, loyalty, corporate opportunities, all that still applies. Or applies to officers. Officers have right to indemnification similar to directors. So they call it D&O insurance. Now, Part 6, fundamental corporate changes. Types, amendments to articles, mergers, consolidations, share exchanges, dispositions of substantially all assets outside of the regular course of business. Substantially all, the lecturer said that that's about 75% rather than what we might have learned in class, which would be to argue quantitative and qualitative theories that I don't recall arguing. Maybe a case about it. Now, general procedure, board resolution, notice to shareholders, shareholder approval, articles of the change filed with the state. Is that, I think that's 4. Yep. Okay, so merger of corporations. Generally must be approved by directors and shareholders of both corporations. Exceptions, parent subsidy merger, or when rights of survivor shareholders not significantly affected. D, dissenters appraisal remedy. Shareholders who do not like the fundamental corporate change may enforce the corporation to purchase their shares at a fair price if they give the corporation notice of intent to demand appraisal rights before a vote is taken, do not vote in favor of the change, or demand payment after the change is approved. E, tender offers, a widespread public offering to purchase a substantial percentage of the target shares. Regulation under Federal Williams Act. If a bidder makes tender offer and the offer will result in the bidder obtaining more than 5% of a class of securities of the target, the bidder must file a Schedule 14D. That's under the Williams Act. Schedule 14D contains extensive disclosure regarding the bidder's identity, source of funds, past dealings with the target, and plans concerning the target. Offer must be open for at least 20 days and must be open to all members of the class of securities sought. Shareholders must be permitted to withdraw tendered shares while the offer remains open. If the offer is oversubscribed, a bidder must purchase on a pro rata basis from among the shares deposited during the first 10 days of the offer. If the offer price is increased, the higher price must be paid to all tendering shareholders. The management of the target must either 1, give its shareholders a recommendation concerning the offer with a statement of reasons, or 2, explain why it cannot make a recommendation. And H, lastly, Act also prohibits any false or misleading statements or omissions in connection with the offer, the tender offer. Part F, control share acquisition statutes. State law providing that if a designated stock ownership threshold is crossed, the shares so purchased will not have voting rights unless the holder of a majority of the disinterested shares vote to grant voting rights in the acquired shares. Limitation on scope. Must be limited to corporations or transactions having a significant connection to the regulating state. Dissolution and liquidation. Voluntary dissolution. If shares have not yet been issued or business has not yet commenced, a majority of the incorporators or initial directors may dissolve corporation by delivering articles of dissolution to the state. After shares have been issued, corporation may dissolve by a corporate act approved under the fundamental change procedure. Effective dissolution. Corporate existence continues. Corporations not allowed to carry on any business except business appropriate to winding up and liquidating its affairs. A claim may be asserted against a dissolved corporation even if it does not arise until after dissolution to the extent of the corporation's undistributed assets. If the assets have been distributed to shareholders, a claim can be asserted against each shareholder for a pro rata share of the claim to the extent of the assets distributed to the shareholder. B, a corporation can cut short time for bringing known claims by notifying claimants of a filing deadline. And C, unknown claims can be limited to 5 years by publishing notice of the dissolution in a newspaper in the county where the corporation's known place of business is located. C, administrative dissolution. The state may bring an action to administratively dissolve a corporation for reasons such as the failure to pay fees or penalties, failure to file an annual report, and failure to maintain a registered agent in the state. Judicial resolution, dissolution, the general attorney, the Attorney General may seek judicial dissolution on the grounds that the corporation fraudulently obtained its articles of incorporation or that the corporation is exceeding or abusing its authority. 2, shareholders may seek judicial dissolution on any of the following grounds. A, the directors are deadlocked in the management of corporate affairs. The shareholders are unable to break the deadlock and irreparable injury to the corporation is threatened, or corporate affairs cannot be conducted to the advantage of the shareholders because of the deadlock. B, the directors have acted or will act in a manner that is illegal, oppressive, or fraudulent. And C, the shareholders are deadlocked in voting power and have failed to elect one or more directors for a period that includes at least 2 consecutive annual meeting dates, or corporate assets are being wasted, misapplied, or diverted for non-corporate purposes. And 3rd, creditors may seek judicial dissolution if the corporation has admitted in writing that the creditor's claim is due and owing and the corporation is insolvent. Or B, the creditor's claim has been reduced to judgment, execution of the judgment has been returned unsatisfied, and the corporation is insolvent. Certification of authority of foreign corporations. Corporation may not transact business within state until certificate of authority is obtained. Foreign corporations may not be denied certificate merely because the laws of its state and corporation differ from host jurisdiction. And last, if a foreign corporation is doing business in a state and has not obtained a certificate of authority, it generally cannot bring suit in the foreign state, although it can defend suits. Part 9, Rule 10b-5, Section 16b, and Sarbanes-Oxley. Part A, Rule 10b-5. Rule 10b-5 makes it illegal for any persons, Romanet 1, to use any means or instrumentality of the interstate commerce. Romanet 2, in connection with the purchase or sale of a security. Romanet 3, to employ any scheme to defraud, make an untrue statement of material fact, or omit a material fact, or engage in any practice that operates as a fraud. A, what is materiality? A substantial likelihood that the reasonable investor would consider it important in making an investment decision. B, intent. What's intent? For the purpose of understanding 10b-5, the conduct must have been undertaken with an intent to deceive, manipulate, or defraud, that is, scienter. Recklessness as to truth also appears to be sufficient culpability. C, the defendant need not have purchased or sold any securities. For example, a non-trading defendant can be held liable to a person who purchased or sold securities on the market on the basis of misleading press release. A private plaintiff must prove reliance on defendant's fraudulent statement or conduct. In cases of omission, reliance generally will be presumed. A private plaintiff must show that defendant's fraud caused plaintiff damages. Damages are limited to the difference between the price paid or received and the average share price in the 90-day period after corrective information is disseminated. And so this is private plaintiffs. Showing reliance on fraudulent statements or conduct or omissions. Reliance generally will be presumed. Okay, for the private plaintiff, show that the defendant's fraud caused the plaintiff's damages. That's the burden of proof. Damages are limited to the difference between the price paid or received and the average share price in the 90-day period after corrective information is disseminated. Rule 10b-5 also prohibits most instances of trading securities on the basis of inside information, that is, information not disclosed to the public that an investor would think is important when deciding whether or not to invest in a security. Within that section, there's 4 more points. A person violates Rule 10b-5 if by trading he breaches a duty of trust and confidence owed to the issuer, shareholders of the issuer, or in the case of misappropriators, another person who is the source of the material non-public information. 2, any person who breaches a duty not to use inside information for personal benefit can be held liable under this rule. And if an insider gives a tip of inside information to someone else who trades on the basis of the inside information, the tipper can be liable. Also, if the tip was made for any improper purpose, for example, in exchange for money or a kickback as a gift or for reputational benefit. And 4, the tippee can be held liable only if the tipper breached the duty and the tippee knew that the tipper was breaching the duty. Section 16b, I think this is your short swing, requires surrender to the corporation of any profit realized by any director, officer, or shareholder owning more than 10% of a class of the corporation stock from the purchase and sale or sale and purchase of any equity security within a 6-month period. Sale or purchase test. Type of sale in which abuse of inside information is likely to occur. Transactions occurring before one becomes an officer or director are excluded, but transactions occurring within 6 months after ceasing to be an officer or director can be covered. 2, the section applies to publicly held corporations, 1 with more than 10 million assets and 2,000 or more shareholders or 500 shareholders who are not accredited investors in any outstanding class, or 2 whose shares are traded on a national exchange. Accredited investors include high income or net worth individuals and officers or directors of the issuer. And 3rd, profit is determined by matching the highest sales price against the lowest purchase price for any 6-month period. May be either a gain or an avoided loss. Now, Sarbanes-Oxley is discussed, and is that it? Okay, this will be the last section, near and dear to my heart. Applies to companies, 1 with more than 10 million in assets, 2,000 or more shareholders, or 500 shareholders who are not accredited investors in any outstanding class, or alternatively, whose shares are traded on a national exchange. 2, requires covered companies to establish an audit committee by board members which oversees work performed by the registered public accounting firm, establishes internal procedures for receiving and handling complaints about the company's accounting, internal control reports. I'm sorry, what did I say? Control. Internal accounting controls and auditing procedures. The CEO or CFO of a similar person of covered companies must certify in each report, among other things, that the officer has reviewed the report. Based on the officer's knowledge, the report is true and does not contain any material omissions. And the signing officer has reviewed the report. Based on the officer's knowledge, the report is true and does not contain any material omissions. And third, the signing officer is responsible for establishing internal controls, has designed such controls to ensure that material information is made known to the officer, and has evaluated the controls within 90 days prior to the report. If a company is required to restate financial reports because of misconduct with respect to the reports, the company's CEO and CFO must reimburse the company for any bonus or other incentive-based compensation received by them during the 12-month period after inaccurate reports were filed with SEC or made public. SOX generally prohibits covered companies from making any personal loans to directors and executive officers. And lastly, SOX provides that the statute of limitations for private cases of securities fraud is later 2 years after discovery of the facts giving rise to the cause of action, or 5 years after the action accrued. And that's going to be it for this overview.